My name is Ben Nuelle. I'm the Public Policy Director at Iowa Pork. Have been there for about 2.5 years now. Before that, I worked as a agriculture policy reporter in Washington, D.C. for about 3 years. And then before that, a farm radio broadcaster here in the state of Iowa, as well as an agriculture specialist for Senator Ernst. But the next guy next to me really doesn't need an introduction. Eldon McAfee graduated from Iowa State University in farm operations and then farmed before attending Drake University Law School. He was with the Des Moines law firm Beving, Swanson, and Forrest for more than 23 years until several years ago when he and his colleagues joined Brick Gentry Law Firm and formed their agricultural law group. Eldon provides legal counsel for the Iowa Pork Producers Association, the Iowa Cattlemen's Association, Iowa Poultry Association, and other Iowa farm organizations, as well as individual livestock crop producers and ag businesses. So welcome today, Eldon, and glad to have this conversation. We're going to talk a little bit about DNR rules here, some other court cases, and other manure-related matters. So, Eldon, I guess, kind of take it away here.
All right. Thank you, and good morning. Yes, manure. That's what we're here for, right? I've been, as Ben said, and a lot of you know my background, from southwest Iowa, Cass County, Atlantic. Anyway, went to Iowa State in the 70s. All I wanted to do was farmed during the 80s. Well, we know what the 80s were like, but I was a dairy farmer, kept the wolves away from the door, and decided, as one attorney put it, and I've told this story before, so bear with me. You know, the good thing about getting older is if you don't remember telling the story before, chances are most people don't remember hearing it before, at least at my age. But anyway, there's an attorney I know pretty well who said, McAfee, you're pretty proud of that story, how you used to milk and came up through the ranks and milked, and then you dairy farmer, and then became a lawyer. Those of us who grew up on dairy farms, which he did, and went straight to law school, those of us who grew up on dairy farms think you were a little slow in the uptake, that you had to do it 10 years yourself before you could figure out that there's maybe a little different way to make a living than milking cows twice a day, 3 times for some people. At any rate, good to have you here. I know it's been a challenge for some of you to get here, so we're thankfully safe travels. And what you have here, for those of you who didn't get one, there's a hard copy of what I'm going to talk about. They're on the table back there on my right-hand side, and maybe someone can bring some around to you if you need them. When you look at this, and this is typical for me, and Ben puts up with me here, along with other folks at Iowa Pork who look at my slides and say, wait a minute, there's 76 of them here, and you have an hour. Well, and I keep talking now, so I'm taking my time away, and besides that, I have a table of contents on my PowerPoints. I have violated every rule there is out there on PowerPoint presentations, but the way I look at it is, a lot of what I talk about are statutes, rules, court cases, and if I just, give you a bullet point, I'm leaving some things out. So I try and give you a reference you can use, and I know you all take it home and read it religiously. Notice I 3-hole punch it every year so it can go in a binder, keep it right there on your desk. Anyway, seriously, I'm trying to get, my goal is to give you a lot of information here, pack it into slides, that if you need that reference, you just say, wait a minute, McAfee talked about something like that, and there's a table of contents there for you so you can find it. Maybe it's not useful, I don't know, but it's information there, and it's there for your use. We are not going to be covering every one of those slides. I will be skipping through quite a few of them, but I'll try and talk in general. Looking, and Ben will jump in here. Ben has to put up with me on what topics we're going to cover, but you can see from the table of contents we're going to talk about nuisance here in a minute. Short discussion, thankfully. Then we're going to talk about ag fraud, trespass laws, get into some DNR issues. And then, how many here remember that thing called the Air Compliance Consent Agreement from EPA in 2005? 19 years ago. that darn thing has reared its head again. And when I heard about this last summer, whenever, I thought, you got to be kidding me. We're going back to dealing with that again. But we'll talk about that because it's back in a form anyway. We'll talk about that. And then, oh yeah, that little thing called California Prop 12 and Massachusetts Question 3. We'll cover some of that. And Ben, I've used up 6 minutes.
I got my
already.
timer set, so we're
All right,
good.
go ahead.
So starting out here, Eldon, as we look at kind of these ag nuisance cases across the state, when you go from the mid-1990s to now, we're seeing trends where we're seeing less of those. Can you kind of talk about why that is and why we're seeing less trials and that sort of thing?
Well, first of all, knock on wood, we're seeing that we are doing very well in the nuisance case area now. But I've been here a few times before in my career, and then lo and behold, several get filed. I'm on slide 3, and that gives the trends, the second bullet point and the third bullet point, and that's what Ben is talking about from 94 to 04, and I've talked about this in past presentations. The verdicts were going against us as an industry. And then go from 2008 to 2019, same number of trials, 4 swine, 3 cattle, only 1 verdict against us. And believe me, if that's your verdict, that hurts just as much as if there were 100. I'm not trying to downplay that. But the trend has been towards 2 things. The trend has been towards verdicts in favor here in Iowa for the livestock producer. Now, so right now, first of all, the last bullet point there, the last 3 trials were all jury verdicts after 2- and 3-week trials for the livestock producers. This is when juries hear all the evidence, not what they read in the newspaper. I had to get that dig in there. That how terrible it is. These were jurors who heard people say yes. I almost said claim. They testify that how terrible it is. Okay, that's their testimony. But then other people get up and testify, I live there, I'm a neighbor, I deliver mail, whatever it is. Yeah, you smell it. I'm not going to say you don't, but it isn't anything that I'm not, it doesn't bother me. I still live my life as I want to live my life. I'm giving you some example testimony of people who go for runs in the morning, in the afternoon, jog, take walks. They go right by hog buildings. They could go a different direction, but no, doesn't bother me. And once in a while, I sneak up there and look through the curtain to see those little baby pigs. And I'm sure there's no biosecurity policy at risk there. But anyway, the point is, when we go, luckily in Iowa here for us, when we've been going through trials, which you don't want to have to go through because people like me charge quite a bit for those things, we as an industry have done very well in front of juries. So Ben, you asked me why, what's the trend? One, why as we sit here today, I don't know of an ag nuisance case for livestock or anything else. We have a dairy stray voltage case that's been decided, but besides that, I don't know of any on file right now. Now, I don't always, it's a little hard to ferret those out sometimes, but that is a great thing for the industry. And why? I believe 2 things. One, what we have here on this slide. We've been successful. I say we in general in the industry have been successful in those trials. That's the important thing. And then also, I'm going to start skipping slides already. We have a nuisance defense here, slide 5, the Animal Feeding Operations Nuisance Defense. We have another one that was adopted by the legislature in 2017 that is kind of a damages cap. I'm on slide 6. But then in 2 years ago, well, 2 years ago in June, the Iowa Supreme Court, after years and years of decisions, well, was Iowa's nuisance defense constitutional? No, you had to do this, you had to do that. The Iowa Supreme Court, by a very close vote, 4-3, said enough is enough. It is constitutional. The legislature has the authority to adopt a law like this, and it is constitutional, so I believe that has really helped, those 2 things. And I go to my next slide. Slide 8 is where I have to preach a little bit here. The Iowa Supreme Court returned livestock producers to having protection from nuisance lawsuit as enacted by the Iowa legislature There needs to be a but in there. But livestock producers cannot take that for granted, and to qualify for that protection must continue to use good management practices, the same practices that juries have found to be effective. That's my narrative on those cases, and that's where we sit today. Okay? Any questions about nuisance law? Okay? Slide 9, I lay out the I'll use the term things producers should do to try and avoid even having to worry about a nuisance law. I said a few years ago at this seminar, I made the statement that the best nuisance case to prepare for is the one that is never filed, okay? Or the best one to defend is the one that is never filed. That's these factors here. Don't let your guard down just because McAfee is sitting up here telling you no trials, we've been winning them, no cases on file. Keep doing what you've been doing and do more. The Coalition to Support Iowa's Farmers is a great resource for producers if you have concerns about your expansion or whatever and need to work with someone to help you evaluate your neighborhood, evaluate the regulations that you need to comply with, et cetera. Ben?
Yeah, and so I guess, Eldon, moving on, we had some huge news out of the Eighth Circuit Court just here in early January with 2 trespass laws. I know throughout the years, you and I both would get questions from folks, okay, where are we protected? And so now I guess the big news here is 2019 and the 2021 laws are considered constitutional. So just talk about how that's a huge win for producers and the protections they have now.
What we're talking about here, if you look online, if you Google ag, what do I have here on slide 10, ag fraud law, you'll get some hits. But if you Google ag-GAG, and I refuse to say that, I refuse to say that word because that's what the media pinned on us, and that media way back were not our friends, okay? But that term, a whole bunch will pop up. And what should pop up, pardon me, January 8th, 2024, just a few days ago, the Eighth Circuit, and I'll talk in detail here, don't worry, they, in my opinion, these justices, and there will probably be a motion to reconsider and all the things lawyers do, but this is the Eighth Circuit, federal court, one step below the U.S. Supreme Court, ruled on 2 laws that we're going to talk about that had been found unconstitutional here by the U.S. District Court, Southern District, as infringing on free speech. The Eighth Circuit looked at that, and and you can read those opinions there if you Google it, they're online. What the Eighth Circuit judges, in my opinion, said was, on one hand, we have property rights. Your right, whatever your property is, to not have trespassers or anyone else come on that property if they lied to you to get there, have the right to harm your operation, whatever your business is. Well, these, at least all but one of these laws is specific to agriculture and to livestock. It's been discussed differently in the media, but I think basically the Eighth Circuit, I've said that several times now, they said, if you're going to trespass, you really don't have a lot of rights once you get there. You broke the law to get on that property, and now you take a video. This electronic surveillance is one of the laws we'll talk about. They upheld that in the Eighth Circuit's analysis, overshadowed or outweighed any rights to free speech that because they broke the law to get there. Okay, all right, now you know how I feel. Okay, slide 10. All right, we have 4 laws here. 2012, first law, ag fraud law, criminal misdemeanor penalties for 2 things. Using false pretenses to get on the property, basically a trespass, or making a false statement on a job application to gain employment there. So, I covered up what happened. The U.S. District Court said unconstitutional, both of those portions of the law as an infringement on free speech. The Eighth Circuit, 2 years ago, not this year, this is a first decision, the Eighth Circuit ruled the access provision, or the trespass part of it, was constitutional, and that's where they first laid out this private property rights issue of, hey, even though if it's a trespass and they don't steal anything, they just trespass, that's still a crime, and that's important to your rights as a property owner to exclude others you don't want there. And they ruled it was constitutional. The employment provision they found unconstitutional in that case because they said it was too broad. It wasn't narrowly tailored enough with intent and to cause physical harm or harm to the operation. They said it was just too broad, so they found that free speech outweighed that. That was back in 2021 with the 2012 law. This gets a little confusing to describe because while these laws, the courts don't move real fast, and in between, the Iowa legislature was busy trying to help producers out here, okay? So in 2019, the Iowa legislature passed a second law that really was modeled, and the Eighth Circuit agreed with this. It was modeled after an Idaho law that had been upheld as far as the employment part, okay? So the 2019 law says it's a crime to use deception to gain access to or employment at an ag facility with the intent, this is the key, intent to cause physical or economic harm or other injury to the operations, animals, etc. Okay. Then we go to March of 2022. The U.S. District Court looked at that 2019 law and said, nice try, but no, it still infringes on free speech, unconstitutional. So here's where we come to. We're on slide 13. The Eighth Circuit, just on January 8th, looked at this and said, no. When they added, the legislature followed what the courts had told them to do, is put in, your problem with the first law is you didn't have intent and you didn't have the requirement to cause harm, etc. So that's what the legislature did, and the Eighth Circuit said, yes, you did what courts told you to do. It's constitutional. And I just pulled out some quotes there. It filters out trespassers who are relatively innocuous and focuses the criminal law on conduct that inflicts greater harm on victims and society. I think that's a pretty strong quote from the Eighth Circuit about how they feel about the legislature's ability to make it a crime when someone breaks the law to get on someone else's property, and it's a permissible restriction. Okay, now we go to, keep in mind, now we're kind of stepping back, 2020, the legislature adopts a law called the Food Operation Trespass Law that just says basically entering or remaining at a food operation without the consent of the owner is a crime. Very straightforward, to the point. That was never challenged in federal district court, but we've talked about this before. 2 years ago, just now, an Iowa district court judge in a criminal case that was ultimately dismissed for someone who had trespassed and entered a hog confinement operation. The Iowa District Court judge followed the Eighth Circuit law or the decision from 2021 and said, no, that is constitutional because it was trespassing, and that law was constitutional. Okay. Now we go to 2021, and I'll try and move right through this. 3 laws were passed. I'm on slide 16. The Livestock Transportation Law, and makes it a crime, a person who knowingly stops, hinders, impedes, boards, or obstructs, otherwise interferes with motor vehicle transporting an ag animal. Makes first offense a misdemeanor, subsequent offenses Class D felonies. Okay, that law has not been challenged in court. Okay, so that's in effect. Unauthorized sampling. This was part of the same law I'm going to talk about next. A person who knowingly enters private property with consent and obtains samples of bodily fluids, soil, air, etc. Same thing. First offense, misdemeanor. Subsequent offenses, Class D felony. All right? Hasn't been challenged. Then we come to the one that caught most of the attention, the electronic surveillance law, part of that same statute that was passed by the legislature. A person committing a trespass who knowingly places or uses a camera or electronic surveillance device that transmits or records images or data while the device is on the trespassed property is guilty of a crime. First offense, aggravated misdemeanor, subsequent Class D felony. What happened? That law was challenged very quickly within months after being passed. The federal district court here ruled it was unconstitutional, violated free speech. January 8th, second decision, but issued the same day, the Eighth Circuit said, the law is constitutional because trespassing harms privacy and property interests, and trespassers, quote here, exacerbate that harm when they use a camera while committing their crime. The act is tailored to target that harm and redress that evil. Again, I think very strong language from the Eighth Circuit about their thoughts about property rights and then free speech. Not that I don't think you can say any of our circuit courts around the country are anti-free speech, but there are property rights that outweigh that at times, and you break the law, you trespassed, this court is saying that's a crime, and I've already went over how I feel about that. Slide 20. How can we put all this together, okay? Where do we stand right now for you as producers in the state of Iowa? First of all, we're one of the few states that have had our laws upheld now as of January 8th, okay? Idaho had part of theirs upheld, and there is a decision out of Texas that isn't getting much attention here on drones. The rights, property rights and drones. If there's a drone flying over your property in Texas, taking video, and that includes animal feeding operations, they made it a crime for that drone to be flying over your property. It was challenged in federal district court in Texas, thrown out for being unconstitutional. Their circuit court did what our court did and said, nope, it's constitutional. It's your property right not to have them. And it was challenged by the National Press Photographers Association, and the circuit court upheld the Texas drone law. I think you might be hearing about, there was a law introduced last year, a bill introduced last year in the Iowa legislature that was modeled somewhat after that Texas law, and that was before the circuit court down there upheld it. I think you'll be hearing about that bill again this year with the Eighth Circuit ruling like they just did and the circuit court decision there. I think you will be hearing about that drone law similar to Texas's. But how can I put it, and then we'll talk about some other things here, and we'll keep moving here. All right, we have 4 laws that were passed. And contrary to what you read in the media that focuses on 3 of them were found unconstitutional, they failed to note that one of those rulings with the Eighth Circuit, yes, was unconstitutional, but one was constitutional. But where do we stand right now after the Eighth Circuit has ruled? We have the 2012 Ag Fraud Law is constitutional as for trespassers, in effect. But then we moved to 2019. Both parts of that law, the unauthorized access and the employment provision, are constitutional. The 2020 trespass, food operation trespass law has been found unconstitutional in the Iowa District Court. And now the electronic surveillance and trespass law has been found to be constitutional. 4 laws basically that say you trespass, here's 4 laws that would make that a crime based on what you do after you get there, okay, the intent to cause harm, etc. And now for the first time as of January 8th, we have the law upheld for those that lie on a job application in an egg production facility and then with the intent to cause harm. So now we have protection in the employment context, which we haven't had before. Okay? What are some well, a couple of things. One, is there going to be more court action here? I'm not sure what will be done following the Eighth Circuit decisions, but there can be motions filed to have them rehear it, look at it again, maybe all the Eighth Circuit justices look at it. And then, of course, and there has been discussion of this in the media, will there be an effort to get the U.S. Supreme Court to look at this? Because U.S., let me back up, the circuit courts out of that rule North Carolina and other areas of the country, Kansas, which is in the 10th Circuit, have ruled the other way. The same level as the 8th Circuit, the 10th Circuit, and I forget what North Carolina is, First Circuit. Anyway, those circuit courts ruled for the free speech and found the laws similar unconstitutional. So we have a split in the circuits here, and so there have twice those decisions have been presented to the U.S. Supreme Court, what we call a writ of cert, for the U.S. Supreme Court to look at it, and they have denied cert for the 10th Circuit ruling and the one out of North Carolina. So now that the 8th Circuit has ruled for constitutionality, and then we also have the Texas drone decision, will the U.S. Supreme Court take these up? I'm certain there will be applications filed. One's being prepared for the one out of Texas as we speak. We'll see what the U.S. Supreme Court does. 2 times before, the U.S. Supreme Court has refused to take these cases. So we'll see. All right.
So yeah, right now, if anybody has any questions on this subject, and if you have a question, just remember you can just raise your hand as we're moving along here too. I guess
I want to add, you can't shut me up, Ben, sorry. I'll get my words in. Slide 21. And as you know, I try and, okay, court decisions, makes it a crime, et cetera, but what should producers be doing, okay? Yeah, like the nuisance defense, here we have court decisions supporting you with that. Those people who do that can be found to have committed a crime. But you really just don't want to have to deal with any of that, right? So what are some practical steps here? You probably know some of these steps better than I do. I'm not up here to preach to you, but keep up what you've been doing before I lay these bullet points out. And I know in the employment context, it's tough. It's tough reviewing those applications. Hopefully the threat of a criminal law behind you will maybe cut down on those who will try this, but don't let your guard down on doing the other things for security to try and make sure those who don't have your permission to be there don't get there. Trespassing or, I'll use the term lying on a job application. Okay? All right, Ben,
Yeah, so moving on here to DNR rules, Chapter 65. Those are animal feeding operations rules that regulate livestock producers. We've been working on that with the livestock barnyard here for, I think, the last, 2 years, Eldon, on making sure what's going on there. So
August 12th, 2022.
If you can kind of explain kind of some of the high-level areas we're looking at and what we're concerned about.
All right. Again, DNR had proposed to take a look at a fairly major rewrite of DNR rules, Chapter 65, that affect animal feeding operations, and issued that first draft in August of 2022 in what they called an informal public comment process, and released it. We all took a look at it, and there were a lot of things in there that, to DNR's credit, they released it to stakeholders on the ag side, and also stakeholders on the environmental side. Everybody got to take a look at it. They made some changes, some significant changes. I could sit here for the next 20 minutes and talk about things that were originally proposed that DNR has changed as a result of the comment, and many of them that we had concerns with, we being agriculture. Anyway, another version was released, I believe, and then along came there's an executive order issued by the governor's office about a year ago, which said you need to streamline your rules. Okay, so then DNR goes back to the drawing board, takes some things out to comply with the executive order, worked on it again this summer, again this fall, and now the EPC on November 21st, just a few, 2 months ago, has issued it for the formal rulemaking process. It's published. There's a version there for you to take a look at, and we can help you. I think I give the links here. You'll find it. The EPC, the comments, written comments on this proposal close on February 23rd. As you'll see here on this slide 22, there are 2 public hearings. Okay, you're thinking, all right, what should we be concerned about, and what comments should we make? And Ben, you've been working on this quite a bit too. But what we have here are the changes on slide 23 that really are in the rule. A lot of it is just housekeeping, I would call it, right? we have the general division, and then they put references to the code are taken out. Some have been left in. Eliminates the director discretion rule. Now we're talking history. Anybody remember the DNR director discretion rule? I don't know how many years ago it's been when the DNR director at that time was concerned about not having authority to just look at something and say, even though it meets all the requirements of the law, it just isn't that operation should not be issued a permit or allowed to build. Had a lot of concern. Worked on that quite a bit. And ultimately, when it was adopted as a rule, the Iowa Legislative Administrative Rules Review Committee entered an objection to it, and ultimately that made it unenforceable according to how the DNR looked at it, so they are proposing to take that out. It's never been used. Anyway, all those kind of housekeeping things, but what are the substantive issues? Slide 24, floodplain regulation. Those of you who deal with this, take a look at this because you'll be looking at the siting atlas to use instead of the current process we have where you do a proposed order, and I'll let you take a look at that. Generally, we feel that's a good change as long as that siting atlas and the alluvial the maps are accurate, okay? Here's the biggie, two biggies here. The biggest one is the karst. Karst terrain is a terrain in primarily northeast Iowa that is, some would say, you have this bedrock that is porous, limestone, etc. I'm giving a poor description of it, but it causes groundwater concerns, okay? So, pardon me. What we have, there's a little history here. The previous proposals that came out from DNR had a proposed change in the rule that would, it lengthens or makes the distance greater, I guess is the term I'm looking for, between the bottom of a manure storage structure and the top of that bedrock in karst terrain, trying to make sure it is a very serious groundwater concern. There's no question. Karst terrain is porous. You can have pollutants if they have the opportunity to, it's easier for pollutants to percolate through that porous bedrock, and again, that's karst terrain. So the proposal was, right now it's 5 feet. I'm talking generalities here. The proposal was to ban it within the first 5 feet, and then in the next 10 feet or 15 feet total, you could, if you had karst terrain and bedrock there, you had to, you had to put in a 5-foot continuous clay layer or a liner of some kind, etc. I'll say this, some would argue with me, imagine that, but I'll say that many felt that that just made it a prohibition. You had to have 15 feet of separation or you couldn't build, where right now it's 5 feet in effect. You can still build within the 5 feet under the current rule if you have that liner. So, but the ultimate version that has been published for public comment is the current version, and DNR is looking for comments. Their earlier proposals are out there, but the current version repeats the current rule, and they're looking for comment on whether the current rule should be changed. Any questions on karst if I kind of messed that up? But that, if you're not in that area of the state, quite luckily for you, you don't have to worry about that. But the producers who have operations in that area, it is a huge concern because sometimes it means whether they can build or expand their operations or not, okay? The second issue, master matrix, the proposal, and this is and you need to take a look at this if you're concerned either from the individual producer as a consultant or county supervisors, etc. Right now, every year to use the master matrix, a county board of supervisors must opt in every year. They just file a notice with the DNR saying, yes, we will use the matrix, and they have to do it in the month of January every year. If they don't do that, then they don't get to use the matrix for that next year. They do it every January. The proposal here from DNR is to flip that around. Once you opt in, you don't have to file anything else as a county until you decide to opt out. So it's switching it around that, so again, they don't have to do it every year. As an organization, we have some concerns about that. If there's new supervisors on board that aren't aware of the fact that they've always opted in, we believe it should stay the way it is, that they should just file it every year. It's not that hard. Just take every January, have it on their list of things to do if they want to use the matrix to opt in. Okay, Ben?
Yeah, and so are those kind of the top areas you want to talk about as we keep moving this conversation forward with these rules?
Yes, that covers the top in the proposed rules. So if any of you have questions, let me know, but keep an eye on the Iowa Pork Producers Association, Iowa Farm Bureau, Iowa Cattlemen, Iowa Poultry, and others will be filing comments, written comments based on what I've talked about here with EPC by the deadline of February 23rd. If you want to file individual comments or get a hold of your organization, work with your consultants, et cetera.
And I think moving forward here too, if you could kind of discuss some updates to manure management plan, due dates, things like that. I think that's moving here in some of these other slides, and going into that real quick before we get into this federal EPA rules here.
Yeah, we're doing pretty well on time, aren't we? Okay. Slide 26. You may have heard over the past several years, there have been producers fined, usually around $3,000, if they miss their due date to send in their updated MMP. All right, and we know that every 4 years you have to submit a phosphorus index MMP, and then in between every year you have to update. If there is an update, you have to provide that updates. If nothing changes, you still have to file a notice that it's an updated MMP, and of course pay your compliance fee. Funny how that works. Anyway, some producers, primarily producers that were doing their own, and some producers will do their own updates and then work with someone to do their every 4 years P-index MMP. But, all right, I take a deep breath because the media has been reporting and DNR has been fining producers for missing those for 3 consecutive years. And some of the media reports have basically been, what a bunch of scofflaws. They're not filing their MMPs. MMPs are important to know how much is being applied, et cetera. And, you know, we got a bunch of lawbreakers out there. Well, let's take a closer look at those notices from DNR, which we've done. And this summer, one producer, and I know a lot about it because he contacted the Pork Producers Association, and we took a look at it, and those notices would say, all right, your MMP is almost always due, is always due the first of the month. But those notices throughout the years have said, well, first of all, way back when, so to speak, DNR sent reminders out. Well, DNR stopped doing that a number of years back and said, we're not going to send out reminders unless you're on the electronic e-filing updates, and then they do send reminders, but they don't send reminders in the mail. So producers were expected to keep track of when theirs is due, which month. 1 month out of the year, the first of the month. All right, so what was happening is they would send a notice that said, along about the 15th of the month, your MMP was due the first of the month. And I think I have the language in here. Well, maybe, I don't see it right now. Anyway, that notice then would say, to avoid a monetary penalty, you must file it by the end of the month. Well, at least there's several producers, and this one producer that contacted us said, well, I did what they said. I did it every time. I wouldn't file it the first month. They'd send me a notice, but that notice would say notice of violation at the top. But he said, then I would always file it by the end of the month to avoid the monetary penalty. But this year, I think his were due in March or something, he got hit. The next notice he got this year said, and wording changed a little bit. But then he got a notice that said, you owe us $3,000 or whatever it was. And he was very upset about that. He felt he had been doing what they said. So we provided a challenge to DNR to the penalty, and based on the language in those letters, and DNR agreed. He did what the letters said. He always met that second deadline. Now, we looked at some of the others who have been fined and looked at their orders. Sometimes they didn't always meet that second deadline, so there's not much of an argument there. 2 points I want to make here. First point, that letter is not going to read the same way the next time that goes out, okay? Meet your first deadline, the first of the month, if you're filing them yourself. Those days are over. You got to meet that first deadline. Secondly, DNR has great people, but you got to read, you know, if they say you violated the law, take a closer look at it and make sure DNR is correct in how they're approaching it. And this is an example of that. I mean, you know, I hate to give you percentages, but the percentages are in their favor when you get a notice of violation and then a penalty through an enforcement order. Many times there is a problem there, but always get a hold of DNR, take a close look at it, and make sure there's actually a violation. Now, the rest of these here, in this section, I talk about, I think my heading I used was effective dates of DNR rules. That leads into, real quickly, I'll say, and I talked about this last year, when DNR comes out and says, well, you violated this separation distance, and I have several examples here, groundwater lowering tile, water source separation distances, I'm up to slide 30. And you think, wait a minute, I hired somebody or I did something to make sure I was in compliance, and now they're telling me I'm out of compliance. Make sure that the law they're looking at is the law that you had to comply with when you built, because sometimes that rule changes, but if you were in compliance when you built, that's the law you have to follow. For example, separation distances, etc. We've had several instances where DNR was trying to impose a penalty for a rule that wasn't in effect that way when that producer built. So always make sure that they're looking at the law that applies to you when you built. I'm over on slide 31 now. Right now I think I'll just talk about a couple other things and then move on to the federal EPA issue. A couple other DNR issues I've been contacted about by you when you call. One applies to your measurement to, when you measure a separation distance, the rule is pretty clear that you measure to the area, the closest point of your operation that either houses animals or stores manure. Offices don't count. Loading chutes don't count, etc. Now, I know we're cutting her a little thin there when we're measuring that close, but sometimes you have to, maybe for matrix points, etc. I have been notified from at least several producers saying DNR sometimes still tries to use the closest point of that building even though it's an office. That's not what the rule says, okay? I'm looking at my slides here as to whether I don't know that we need to cover anything further. Maybe we should just, in the interest of time, if you have any questions, I'll be around afterwards, or you can ask them now, but we'll move on to the EPA issue.
Yeah, and so one thing, obviously, we talked about rules we're watching from a state level perspective, but always the pork industry is watching what the Environmental Protection Agency is doing. And here, talking about the Emergency Planning and Community Right to Know Act, obviously, it's been something we've been watching as pork producers throughout the years. And so, Eldon, I think it's slide number 59. And so, can you talk about where we're at and kind of how we're monitoring this and coordinating with the national folks as well?
All right, slide 59, I have it up on the screen. The other slides I just, 20-some I skipped over are things we've talked about in years past. I realize some of you may not have heard that discussion, but please take a look at those regarding whether you have one operation or two, how to calculate animal capacity. I also have some slides in there about winter application, manure application on snow-covered or frozen ground. Yeah, we got some snow out there. So take a look at those if you have that issue. We're not going to talk about them here. Slide 57, right before the one, two before what I'm going to talk about. I always like to mention environmental audits. If you discover a violation in your operation of a DNR rule, you discover it yourself. What you should do to protect yourself from any penalties is file what we call a notice of a self-environmental audit that, hey, I audited the rules in my operation, I discovered I have a penalty or I have a violation, and you submit that to DNR, you tell them how you're going to correct that violation, and there should be no penalty. A very valuable part of it, and that's on slide 57. Okay, slide 59. We're into the federal EPA now. I talked about the 2005 consent decree. I take a deep breath. Again, here it is, it's back. And why is it back? Because that consent decree, if those of you who remember it, those of you who weren't dealing with it then, I even brought my slide presentation from 2005 where we talked about this. Not going to go through that today. But it was designed as you entered into a decree with the EPA saying that if I was in violation of the Federal Clean Air Act, from emissions from my hog, poultry, dairy, whatever barn, then I'm going to pay you a standard penalty, and I lay those, it varied between $200 and $1,000 per farm. I sign that decree, the EPA accepts it, takes my money. What happens then? Well, you wait until we did what we called emissions estimating methodologies. There was a study that went on for years, and it's just now being completed 20 years later, as I have in the slide there, the NOM study, we called it, and they are just accumulating all that data, and what the consent decree said was when that is final, then you agree to do what those methodologies say you need to do to control any emissions from your barns, okay? I think some of us, including me, kind of put all this aside and thought, well, nothing's happening. No news must be good news. Well, as I have on this slide here, the methodologies are being updated in 20 and 2022. The review is underway. The public comment period is expected in early 2024, and that's where we are, but we haven't heard yet about a comment period on these methodologies. And finalization of all AFO emission models in summer of 2024. That's what the EPA is shooting for. We need to watch this closely, and your national organizations are, I can assure you. So don't do anything different now, but just want to remind you that that has reared its ugly head again. Okay? Now, next slide, slide 60. Part of all that was reporting emissions from our farms under CERCLA, the Comprehensive Environmental Response Compensation and Liability Act. I always have to look at that. I can never remember. And then reporting under what we call EPCRA, the Environmental Planning and Community Right to Know Act. Well, that kind of had its separate tract of, we went through, gosh, I remember one year at Pork Congress, it was a big, whoa, we got to have something filed by wherever it was in January, and we were all hustling to get that filed under these reports. Here's where we stand right now as I lay out on slide 60. CERCLA, Congress stepped in 2019 and said farms are exempt. So CERCLA's off the table, okay? But EPCRA, and don't ask me why, but EPCRA was not handled by Congress. It was done by an EPA rule in 2019 that exempted livestock operations from the requirement to report emissions. This law, this is where I editorialize, this law is intended for some hazardous substance that if there's a railroad car that an accident and there's a hazardous substance released into the air, then that's supposed to be reported to the local emergency response reporting people so that the community can be notified, et cetera. But there's also part of the law that talks about continuous release reports from something with these hazardous substances. We, as livestock farms, have long said, wait a minute, that's not us. But and the 2019 EPA rule exempted us from it, okay? Well, lawsuits were filed. Go to slide 61. What's going on? Well, in 2021, there was an executive order regarding environmental compliance, okay? Just a general environmental compliance order. And then in 2022, as part of this lawsuit, the court granted the EPA motion for EPA to reconsider the exemption. Antenna got to go up at that point. What do you mean we're reconsidering an exemption? CERCLA was passed by Congress. They can't touch it. This one was an EPA rule, and the administration and EPA here said, well, we're going to take another look at it. So on November 17th of 2023, just this past November, EPA published Advance Notice of Proposed Rulemaking. And I have a copy up here. It's out of the Federal Register, and I know you all read the Federal Register every day. It's, I don't know, 20 pages it looks like. They go through the background, et cetera. But what they're asking for is comment on, basically, should we still keep that exemption? Well, I thought about filing a comment as one word, yes, but don't think that's going to cut it. Your national groups are looking at this. They are asking for, do I have it here on how many? 48 specific areas they want comment on. I mean, it's a lot that their EPA is saying, well, we'd like you to comment on this, on this, on this. I guarantee you the environmental groups will be commenting on all those areas, and our national groups are working on this. Those comments are due February 15th, so coming up real quickly. I just wanted to let you know about this. If you're interested yourself in looking into this, go ahead. I think you Google it, you'll find it. But that's what's going on air emissions. And again, we all thought, one, the air consent decree would, and the methodologies were taking so long, so maybe that was just going to go away. It's not. Two, Congress exempted us from CERCLA, but the EPA rule exempted us from the reporting under continuous releases under EPCRA. Now that's being revisited. So we have two things we need right there we need to keep an eye on for providing comments.
And then I think moving on to just kind of our final topic of conversation, California's Proposition 12 as well as Massachusetts Question 3. I guess I'll speak just real quickly on where we're at legislatively before Eldon kind of gets in the status here. But again, continuing to work with the Iowa delegation as well as National Pork Producers Council to get some sort of language in the Farm Bill regarding an exemption. So continuing to work there. Appreciate also Senators Grassley, Ernst, and then the House delegation for introducing the EATS Act. But Congress, lots of going on in Congress right now, so we're continuing to have those negotiations. And NPPC is working on that for you at the national level with those members in the House Ag committees and hopefully getting something accomplished there. So just wanted to give you a brief update what we're doing legislatively there. And then Eldon, if you can kind of talk from just the legal perspective and the court side, kind of where we're at with both of these rules here.
All right. California Prop 12 went into full effect on January 1, 2024. I know there's some of you are dealing with that. You probably know more about what's required to comply with it than I do, but it is in full effect. It was kind of quote-unquote phased in starting July 1, 2023, last July with whole pork meat that was in the system as of that date was allowed to be sold, but that's over in California. That's over now. All pork sold in California, whole pork meat, and we define, I give you that definition there. It doesn't apply to all pork. Whole pork meat must, anything sold in California now must be compliant, come from a pig whose mother was kept in gestation meat stall or housing with at least 24 square feet and was able to turn around, which generally means going to group housing and gestation. That's what is required. I have the slides up there of the U.S. Supreme Court decision. We lost. If we are those who didn't want to have to comply with Prop 12, the U.S. Supreme Court, it was a very close decision. I've got some of the details there, but in the interest of time, as some people say that ship has sailed, me as a former dairyman, I say that cow's been milked, so we got to move on. There are one lawsuit. Iowa Pork Producers Association is the plaintiff in a lawsuit before the Ninth Circuit now, challenging Prop 12 on some of the constitutional issues that were not covered in the NPPC lawsuit in front of the U.S. Supreme Court. That was based on the Dormant Commerce Clause, as you know. Can California adopt a law that it regulates beyond its borders? And the Supreme Court said yes, based on how this law is done. But there are other constitutional challenges to that are raised in that case. And we'll see. We should be getting a decision from the Ninth Circuit on those oral arguments here soon. Anything further, Ben, you think? Any Prop 12? I'll move on to Massachusetts question 3. Similar law. I'm on slide 73. It's in effect, but difference between Massachusetts question 3, one of the main differences, and Prop 12, in Massachusetts, their law applied not just to the sale and consumption of pork there, but also any what we call transshipments. Pork that came in, whole pork meat, sold, but then moved on to another state for actual consumption sale, and called transshipments. And Massachusetts has put that on hold while they develop rules on how that's exactly going to work. So they are not enforcing that part of Massachusetts question 3. Okay, but otherwise it is being enforced. I think the real question most producers have is, and there are 2 lawsuits based on that. Triumph Foods, I've got slide 75, is challenging that law, again, based on the constitutional provisions that the U.S. Supreme Court said were not covered in the NPPC lawsuit. So we'll see what could happen there. Federal legislation Ben just talked about. I think the real question is, what's going to happen? Are other states going to do it? And are we going to be dealing with a whole patchwork of these type laws? Do you want to take a vote? I don't know. I would say, I hate to say yes because I don't want them to do it, but I think everybody thinks that could be coming. New Jersey did pass one right away, but it only applied to the production of pork in New Jersey. Probably not a lot of pork. Well, there are some, but it's the laws like Prop 12 and Question 3 that apply to the sale and consumption of the pork, no matter where it is raised. Obviously, that raises the biggest concerns. And again, all I can do is, some of you are marketing that pork now, and others are waiting. I guess all I tell people is work with your distributor, whoever that is, or your packer, et cetera, as far as what you need to do and what you can be compensated for if you have to make any changes to comply.